Hi there, I'm Savannah Mextro with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. On today's webinar, Bob will answer an important and surprisingly common question. Can the bank refuse my power of attorney? Now, before I pass the torch to Bob, I'd like to cover a few housekeeping details. First, a quick disclaimer, and Bob will probably cover more on this later, but today you're going to learn something. You're definitely going to have some awesome information, but you're not going to get specific legal advice. If you are looking for something that is specific to you in your situation, I encourage you to contact us after the webinar. You can give us a call at 810-694-9000. Also remember that today's webinar is recorded. We'll send out a replay of this webinar tomorrow that you can share with your family and friends. If you do have a question at some point during the webinar, I encourage you to put your question in the chat box. We will save time at the end of today's webinar to review those questions. If for some reason we can't get to your question, we will contact you after the webinar. Now, why should you listen to what the folks at Mannor Law Group have to say? Now, first note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys Michigan chapter. Now, lastly, my favorite personal reason, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. We're going to get right into it. And as Savannah said here, I always like to start off with a disclaimer, just that, you know, we're going to be talking about things from the standpoint of generic, and that anything that's related to you specifically, you should get specific legal advice about your specific circumstances. But I think this is a really interesting topic today because this actually reminds me of, it's probably 6 months ago, I was doing a presentation and I mentioned that frequently people have trouble using powers of attorney, that we constantly hear it, that they took the power of attorney to the bank because mom was in the hospital or mom has dementia or whatever the situation was, and the bank refused to accept it or gave them such a runaround that they just felt like they couldn't use it. And this does happen a lot. And I mentioned it at this class that I was teaching, and it was interesting because one of the people in the audience kind of started arguing with me, and they said, well, wait a second, that doesn't sound right, because was it a legal document? I said, sure was, sure, absolutely a legal document, and actually a really well-written document. And so then the idea was, okay, well, how can they not accept it? And so really that's what we're going to be talking about today. The thing is a bank going to accept it? Is the doctor going to accept it? And we really want to look at the circumstances around that, because it could simply be that the circumstances aren't right and they shouldn't accept it, but because you're misunderstanding how it's used or something like that. And we're going to talk about that, how to make sure that you're using the right document at the right time and all those types of things. But too often they should accept it, absolutely should accept it. That's the law, legally they are required to accept it. And they don't, or they give you such a runaround, or they say, well, we got to send it into our legal department, but then they won't let you talk to the legal department. And it gets to the point where it is, the bottom line is it's just untenable, that they're not actually going to be able to, accept it, or that it's not workable. So we've been successful in convincing the bank to do it. I've not actually had a situation where we were not able to get the bank to follow the instructions, but sometimes it is where we really have to go up the chain of command and things like that. And I've had lots of other really talented attorneys tell me that they just got to the point where it was a solid no, that they wouldn't accept it, and that they had to take use some other effort. So let's kind of talk about that. And then I wanted to throw in the other topic of I'll get this question from time to time, is in fact, I got this question today. It was an interesting one. His dad had signed a document appointing his son to be able to make medical decisions for him. And he had said that he didn't want life support or extreme measures taken in the event that they didn't think there was a significant chance of recovery. And when it came to the time of that this happened with his dad, where they got to the point where they said, okay, well, you're going to need life support in order to continue, dad said he wanted it. And then he got it. And the son was like, wait a second, Dad, you appointed me as the person to make this decision. Well, the son was misunderstanding that, because with that document, with the healthcare decisions, it's actually you get to make your own decisions. Dad gets to make his own decisions unless they're unconscious or two doctors have determined that they're not capable of making their own decisions. So that's a big difference from the financial one, which has a completely different standard. So we want to make sure that we got that and we understand what's going on with that, okay? So bottom line is I wanted to kind of break this down into a few different things. We're going to talk about the bank stuff first, or the financial power of attorney first. We're going to talk about the medical one and when and how to use that one and all of that. And then we've got what about alternatives? How do we solve this problem? And again, we've successfully solved this, but ideally we actually solve it in advance. We solve it in advance so that we don't end up with a situation where we get denied the first time. So once the bank kind of cements into their position, sometimes it's hard to move people off of a position. So the idea is to get it set up, make sure that we have thorough planning and thorough designations in place and ahead of time, well before you get sick or deceased, and that will solve the problem. So we're going to talk a little bit about that, because often we're going to be involving a trust in that situation. So if you've heard me talk, you often hear me talking about trusts and how they can be actually very useful alternative to the power of attorney, and we find them actually much more workable, and the banks will actually work with us a lot, typically will a lot easier. And typically it is a lot more organized in the event that we have a trust instead of just using the powers of attorney. So let's break this down. The financial one, can the bank accept it? I asked, what are the circumstances? So a lot of times one of the reasons why the bank isn't accepting it is simply because the person's not alive. And what people don't understand, they say, well, I've been using this power of attorney for 10 years. I've been helping my dad make financial decisions and pay his bills for 10 years. Dad died a week ago. I go to the bank and they're not accepting my power of attorney anymore. Well, that's because the power of attorney is no longer valid at this point, and that's true for everybody. It doesn't matter how it's written. You can't have a power of attorney that is effective after death. That's not how those documents work. It's a lifetime document, okay? And so that power of attorney is not going to be effective after death. So that's really important. Just as a side note, this is just a really interesting practice tip. When somebody dies, don't throw away their power of attorney. This has been something that came up that we've had people that use the power of attorney to sign legal documents or sign a deed or sign something like that, and then the person dies, so they throw away the power of attorney. But then sometimes we need proof that that was a valid power of attorney when you signed the legal document when they were living. Obviously, it wouldn't be valid if you signed it after they died, but if you signed a deed a year before they died, or you signed some other legal document a year before they died, and then you throw away that power of attorney, well, you might need that. So hold on to that power of attorney even after somebody dies, at least for some period of time, to make sure there's not any cleanup issues. Particularly if it's a husband and wife, we're going to want to keep the first spouse to pass their power of attorney. We want to keep that at least until the second spouse dies, okay, and then sometime after that. So that's really important. All right, so then the other thing is we'll often get, oh, you can't use this power of attorney because the account is in a trust. And that's something that really frustrates people sometimes, because they say, oh, my goodness, this was supposed to make it easier, and I take my power of attorney down there and they're not accepting my power of attorney because the account's in the trust. Well, it's good. You're just using the wrong document. You don't take the power, typically, here's the deal, you don't take the power of attorney down at that time. You take the what's called the certificate of trust, which is actually a simpler document than the power of attorney. It's a 2-page document versus a 9-page document for the power of attorney. That 2-page certificate of trust can give you the authority where you can work with the bank then through that certificate of trust. And so that's really important to kind of look at it that way, is, okay, are we using the right document? And that's why bottom line with our clients, it's always just give us a call. The people here in my office are all educated about what documents should be using. We get calls from the bank. Don't leave the bank. Call us while you're still at the bank, or have the teller at the bank, or the person you're talking to at the bank call us, or whatever it is. But the bottom line is those things can be really easily resolved. It gets so frustrating if you say, okay, I took my power of attorney down there. They said I couldn't use it, so I left. Well, just call us, and we'll try to straighten that out right there. But the bottom line is a lot of times it's just you're using the wrong document. Okay. What's interesting about that, though, sometimes you could actually use the power of attorney to act on behalf of the trust. And some people look at that, oh, that could be a good thing or a bad thing. Do I really want the power of attorney to have access to the trust? And the answer is we draft our powers of attorney typically that says the power of attorney. So let's say, here's an example. Let's say dad is his own trustee, because we have a trust, and dad is his own trustee, or mom and dad is their own trustee, and now mom and dad become incapacitated. Can we use the power of attorney to access the assets in the trust? Answer is, it depends on how it's written. You got to look at the power of attorney and see if it has that authority in that. And a lot of them don't, but ours typically do. We typically do want to have that. And then in that circumstances. However, most of the time, so we've had circumstances where it was really appropriate to use that power of attorney to access the trust, but most of the time, what we really want to do is we want to say, okay, let's look at the trust and see who's the backup on the trust, who's the successor trustee on the trust, have them move up. And usually we have to do that through a doctor's statement or various other, there's multiple ways to do that. But the idea is to make it so that they could, really should it be, we shouldn't necessarily be using the power of attorney to access that trust account. We should be making sure the trust is updated so that the next in line is successor trustee, which is a very simple process. It's just a matter of getting doctor statements and then getting a simple certificate of trust from the lawyer. So again, I understand people just want this all to be really simple, and they say, I just want one document that does everything. It doesn't work that way. I used to, whenever I do presentations, I used to talk about the magic pill. Everybody wants that magic pill, right? So I don't watch TV as much as I used to, but I used to watch late night TV, and I'd see these commercials, and they were selling these pills, and it was going to make me thin, and it was going to make me strong, and it was make me smart, and all these things. Those pills don't work, right? There is no magic pill, and there is no magic. You just have to understand what the documents are for. And if you get confused, you just call us and we work it out. We explain, oh no, you had the wrong document there. You want to use certificate of trust. You want to use the power of attorney, whatever the scenario is. And so it doesn't mean that these are hard to use. It just means, you need to know what tool to use. And I do like to use them, call them tools. I often will give the example of tools because, if I have a whole toolbox full of tools, but I don't know how to use them, it doesn't mean there's anything wrong with the tools or that there's anything wrong with that process. It just means we need to know what tool is the right tool for the job. So that's the first part of it. And then I say in theory versus in real life. So the answer to the question, I know we're 15 minutes in now at this point, but the answer to the question, can the bank refuse to accept the power of attorney? And the answer is, well, do you want a legal theory answer, or do you want to know about real life? And what do I mean by legal theory versus real life? Because I can say in no uncertain terms, they cannot refuse to accept that power of attorney. It's a perfectly legal document, and then they can laugh at me, right? I mean, is anybody going to take this into court? I mean, people have. It has happened where people took it into court and say, no, the bank has to accept that power of attorney, and then they win because we have, if it's a valid power of attorney, then yes, but who's going to want to take the time to sue them? And people have. Again, I'll get into that a little bit. But that's where we have that sort of, okay, Bob can declare it to be legal, but that doesn't mean that when you go to the bank that they're going to make it easy for you. So that's where we got to look at reality versus just saying, well, this is what the law says. Well, great. How far does that get you? If the bank manager is refusing to take it, then how far did that get you? So that's where we're at with that. And so a lot of times you have to take it up to the next level, or you have to send it into their legal department and wait. My tip for that, if we have to send it into a legal department, is whoever we're talking to, we're going to say, hey, okay, I'm talking to you, Julie. Julie, can I call you? How long does it take for them to review this, Julie? Okay, Julie, you said it'd probably take about 2 days. Are you near a fax? Do you have an email? Can I just email this to you and you get it to the legal department? And then in 2 days, can I just call back you, Julie, or can I email you, Julie? Because I just don't want to sit back on that phone for an hour waiting on hold till I get to somebody and then explain this. Because if you do that, if you don't get Julie or Sarah or Tanya or whoever it is, then what happens is the next person's gonna be like, we never got the power of attorney. You know, you could have sent it 3 or 4 times. Oh, we never got it. I don't know what you're talking about. We don't have no record of that. And so that's where it really helps if you can just make sure that you're talking to the same person again. And we found that actually most places are pretty accommodating to that. They some of them won't, but then maybe you go to their boss and you say, okay, Julie couldn't help me, but I don't want this run around anymore, and I really want to continue working with this financial institution. So can I talk to the boss? And so since Julie can't help me, George, or Sarah, Julie couldn't help me, but Sarah, can you help me? And again, it's just facts of life, right? You get more bees with honey kind of a thing. So you ask for the manager, you ask for the supervisor, but then you're just really nice to everybody. You never try to irritate anybody and just get through that process. So I will tell you, I've talked to some really good attorneys that went through all that process, and they still couldn't, with certain banks and certain financial companies, they just couldn't get anywhere, and then they ended up having to give up or find an alternative way. What's going to make it more likely they'll accept it? We talked a little bit about trust and how trust can often be much more user-friendly, and I'll give you an example in a second here. But the bigger issue is to make sure the financial company has it before you need to use it, right? So if mom has a bank account and mom wants you to help her with that bank account, you go to the bank and you say, okay, here's mom, here's son, and here's the legal document. Can you take a copy of this legal document, get it through whatever system you have to, put it in your computer, and make it sure, so then they can't say, well, how do we know this isn't fraudulent? How do we know mom actually signed it? How do we know mom, so they can still say those things, but they're less likely to if you go at a time where you're not planning on, you don't need to use it today, and you're, perfectly competent and all those types of things. So ideally, we actually have the bank or financial company accept that power of attorney when mom and dad are both healthy, right? Okay. And we'll dive into that a little deeper. Can the doctor, nurse, paramedic refuse to accept the power of attorney in circumstances? This gets a little bit messier because remember, the person can always make their own decisions. And so that's primarily the issue there, but we're going to talk about it from the standpoint of people will often say, there's even the joke about people that say they tattooed on their chest, do not resuscitate. Would that work? If you had do not resuscitate on your chest, you called the paramedic, is the paramedic going to open up your shirt and say, oh, Bob said do not resuscitate? No, paramedic's probably still going to do their job. Even if it's across my forehead, do not resuscitate, the paramedic was called, they're there to do their job. They're not a lawyer, they're not a judge, they're there to do their job. And they've been instructed typically is do your job, we'll sort out the law later, okay? And so just having, that's not a legally binding thing. Even if you put in a notary thing on the tattoo on your forehead, it's still not that's urban myth basically. And so that's not an option. And then we'll talk about some alternatives here. Okay, so let's move this forward just a little bit. All right, so there's lots of different powers. So just to make sure we're all on the same page, I want to go through some of the basics. There's lots of different powers of attorney, right? There's a financial one. There can be one just for real estate. There's one for just specific issues. I signed a power of attorney one time because we were handling a real estate transaction. I couldn't be in the state at that time, so I gave my power of attorney to somebody else so that they could attend the closing for me and sign my name. And so, but that power of attorney was a special or limited power of attorney, and it was only good for one day. It said, okay, on Thursday is the closing for this property, so I'm granting this person my power of attorney for 24 hours for the day of Thursday, and only to handle this one transaction, so it can be very limited. But the big ones are going to be the financial. Sometimes we just call that the durable power of attorney. That's typically the financial power of attorney. And then there's the medical or healthcare, sometimes called patient advocate, or sometimes people even call it a living will or something like that. So you need both of those, right? Financial power of attorney and healthcare power of attorney. So I just want to make sure we're all on the same page about this, because one of the reasons that sometimes people will come and they'll say, they didn't accept my power of attorney. I said, well, show me the power of attorney, and they pull up the healthcare, but they went to the bank. Okay. Unfortunately, most lawyers call these things durable power of attorney and healthcare power of attorney, and they're both called power of attorney. And so most these get so confused so often. Some lawyers will call the healthcare power of attorney a patient advocate. We've actually started trying to transition into that, but the idea is that we really need to make sure that we're using the right document. Now, why can't you just, you're like, Bob, just make this simple, just have one document. No, sorry, can't do that. They can't have one document. It's got to be two separate documents, because they have, not only are they used for different purposes, but they have different standards of when they can be used. Okay, the financial power of attorney, typically we want it to be effective immediately. You sign it, the person that you've appointed can use it the next day. The healthcare power of attorney is only used if you've been declared incompetent by two doctors. Typically, we don't want to have that provision on the financial one. And even if we do have that provision, it's still a different standard as to how it can be used, because the financial power of attorney, you still have authority, right? You still have authority over that. But the healthcare power of attorney, that person can only act if you physically or mentally are unable to act. So they are two different documents, and you can't. And I've seen people, not recently, but I have seen lawyers try to put them in one, and it's not accurate. That's not legally accurate. Okay. This is something, this is kind of tried and true. Many of you may have seen this graph before, or graphic. Remember these two circles, they call them concentric circles, where they're overlapping just a little bit. And the idea behind this is just to remember that if you that these documents are only good in lifetime, and these things are only good after death. And there's a little bit of overlap, and that's primarily trust that can cover both lifetime and death. But the idea is your healthcare power of attorney is no longer valid after you die. Your durable power of attorney is no longer valid after you die. Guardianship, conservatorship are no longer valid after you die. One of the things to remember, just as a quick note, if you have a durable power of attorney, you typically don't have to go to court and get a conservatorship. If you have a healthcare power of attorney, you typically don't have to go to court and get a guardianship. So I have people tell me this all the time, and it's so unfortunate for me. I see this all the time where people, they don't call me up, they get a referral to me, but then somebody told them they got to go to court, and so then they go to court, and then they come to see me, and they say, well, how are we going to pay for care? How are we going to deal with the long-term care, things like that? And now, not only did we go to the expense of court when we didn't need to, because they had these powers of attorney, but now we have to deal with the court for the rest of our lives probably. And then anything that we've got, it's going to be a lot more costly, and now the judge can say no, and whoever the judge appoints can say no, and there's guardian ad litem, and in other words, do we want to have, I'm not saying that's all bad to have some supervision, but in most cases that's not really what we need or want, right? If it's a good family and everybody's looking out for mom and dad, obviously there's situations where we'd want that court supervision, but we find that less preferable in most cases, right? So if somebody says you need to go to guardianship or conservatorship, even if you don't have these documents, best is to call us first and say, do we really have to go to court? Is there an alternative to go to court? And a lot of times there is. Not always. Sometimes you got to get a conservatorship or guardianship, but a lot of times there is. Okay. And then, of course, we've got the after death options here. So I just like that graphic to show, how important that is. So I wanted to point this out. One of the reasons why we're actually doing this webinar is, can the bank refuse the power of attorney? Well, our friend, Representative Wozniak from Rochester Hills has sponsored a bill to make it so that it is very clear that the bank is supposed to accept the power of attorney. Okay, if it's a validly drafted power of attorney. Several states have passed a similar version of this statute. Michigan hasn't passed it. In a second, I'll tell you about a Florida case where Florida did have a version of this law passed. So, like I say, our friend Representative Wozniak is pushing this through. It's likely to pass, and we're supporting this. We think this is a good bill. I say our friend Representative Wozniak just because I've been personal friends with him for years, but also because he's very much a friend of elders. He was an elder law attorney for many years. He comes to our elder law conferences and has come to our committee meetings and things like that. He's been invaluable in helping us get some progress in meeting with some of the bureaucratic, administrators and things like that, the Department of Health and Human Services. He's probably going to be one of the representatives that we'll be working with to try to get our remote signing bill passed. But we think this is a good bill, and we hope and expect that it will get passed. And then basically it just tells the bank that they're supposed to accept the power of attorney, which is, should be obvious. We shouldn't need a statute for that, but it is helpful. The question is, how much teeth does the law have? But we found as talking to other attorneys in other states that have a version of this statute, that it is actually pretty effective, that once we have this statute in place, it's much more likely the bank's going to accept our power of attorney. So I was going to tell you the story about Florida. So many years ago, oh boy, I'm going to say at least 10 years ago, probably longer actually, I wrote an article and I posted it on our blog, on our website, and it was about the bank not accepting a power of attorney. And it's so funny. The reason I laugh about it is because through the years, I will still get calls. And I remember the last one was some paralegal in California, and she read my blog article and she called me up and said, how did you get the bank to accept it? Because I'm having the same problem. How did you get the bank to accept it? And the story goes that we had a client that was having trouble with this, and the bank was saying, and this is definitely not a requirement, but the bank was saying, okay, well, we will accept your power of attorney if you get a notarized statement from a doctor. So several problems with that. First of all, doctors don't typically have notaries in their office, so it'd be very difficult to get a notarized doctor's statement, number one. Number two is that some people will put that in their power of attorney, that you need a doctor's statement. We don't put that in ours typically. We very rarely put that in there. And in this particular case, it was not in there. So they weren't following the law. They weren't following the terms of the document. It was just some employee at the bank had, in some previous case, the previous document said something about needing a doctor's note. Well, ours didn't have that, but they were just insistent. Well, that's how these work. So the bank employee was deciding what the law is rather than the laws and the courts and so bottom line is, I thought that was kind of ridiculous, and I was a little irritated about it. And so I got on my computer, started typing out my blog post, and I found this court case in Florida where the bank didn't accept the power of attorney. And in that case, the family actually sued the bank and got damages. They got like a whole bunch of money in damages because the bank failed to accept the power of attorney. Well, it turns out that Florida has a similar version to this House Bill 5768, and that's probably the reason why that they were successful on that lawsuit. But I had written about that, and I had written about this Florida case. And bottom line is, in that case, many years ago, and pretty much ever since, we were able to convince them to accept the power of attorney without getting the notarized doctor's note. And the way that we did that was simply, take it to the next level, make sure that we go through their process. It wasn't easy, but we got it done. So, all right. This is another one by Representative Wozniak. And so this one is where Representative Wozniak is working with the Attorney General's office, who has been really wanting to clarify the rules on powers of attorney as it relates to things like transferring assets for protecting them. And I said that on purpose, transferring assets for protecting them, because that's not the term that they use in the law, and that's not what the Attorney General's office would use. They actually would use the term gifting. And if you know me and have heard me talk, I don't like that term gifting, because a lot of times we don't actually want to gift. We're not gifting assets. We're trying to protect them. I mean, we are technically gifting them. Legally, technically, it's considered a gift, but we're not trying to do it for the purpose of then the kid can go out and spend that money, right? We're trying to transfer it so that we can protect it. Sometimes it's just transfer it to the spouse. Maybe it's just transfer it to the wife, transfer it to the husband, and the state's going to call that a gift. And if we don't have gifting powers in the power of attorney, we got a big problem. Often you'll hear me refer to this as one of the extraordinary powers. So a lot of people don't have extraordinary powers in their documents. We encourage people to have these extraordinary powers, and one of them is this gifting or transfer power, okay? Not so that we can give Christmas gifts, but we can protect it from nursing home or veterans benefits or things like that. And so Attorney General's office has been, and through the task force, the governor and Attorney General's task force, they've been pushing for some reform on this. And we want protections, right? We want protections. We want to make sure as much as possible that we can prevent kids from taking advantage of their parents. But that doesn't mean that we want to make it so that families that are trying to take care of each other and are doing the right thing can't do those things without having to go to court and asking a judge for permission for everything. That you should have the authority, the ability to write these into your documents. So the Attorney General wants to kind of make sure that we have some protections there, and fortunately Representative Wozniak stepped up to make sure we don't go too far. Sometimes when the state gets into this and they go too far and they say, okay, we're just going to make it so that these documents can't have gifting. Well, that would really hurt a lot of people if the law said that language. So Representative Wozniak stepped up and made it so that he's going to be the sponsor of this, make so that we can have a bill that can accomplish the goals of the protections without having it be where it just bans it and bans the protections that we can, help for those families that are well-intentioned. So that's good. We think this one will pass too. This is a little bit more controversial than the other one, but we think it will pass also. And the thing about this, and y'all are not going to necessarily like this, but it likely means if this bill gets passed, you'll probably have to come in and sign new powers of attorney. And I know if you've been watching that, I'm telling you that you're probably going to be coming in soon to update your will or trust as it relates to your retirement assets in the Secure Act. And we're going to be sending those messages out shortly. I know it's many of you have been waiting on. Okay, well, when do we get to update our documents for this Secure Act? But what's interesting or unfortunate about it is they didn't time these together, because it'd be nice if we could have you come in, update it for the Secure Act, and then also update your power of attorney. But it's probably, this might be next year or the following year or whatever. But the bottom line is, it is likely that if this bill passes, that we're going to have to update existing powers of attorney. It's not that they're not going to get grandfathered in, but they won't meet the standards of making sure we can still use those extraordinary powers properly. So just be aware of that in the future you may get a message from us saying, hey, sorry about this, but the law has been upgraded and now you need to upgrade. And that one won't be nearly as intense as the Secure Act. That's just going to be, we got to make sure that your power of attorney complies, but be aware that that's a thing that probably will come up in the future. I mentioned this earlier, and I just wanted to put an exclamation point on the point that power of attorney is not the same as guardianship. So I was talking to somebody, they had a crisis situation with their brother, and the nursing home was trying to kick him out after he'd been there for 4 years. And the notes, and I talked to him several times, and we're doing everything remotely, so I wasn't able to see the actual documents he was referencing, but he kept saying he was guardian over his brother, and that's a court-appointed thing. Guardianship is a court appointment, okay? And then, kind of went round and round, turned out he's not guardian, which is definitely a different thing, but he had power of attorney. And so those are different. Power of attorney you do privately. Guardianship, you have to go to court, and it's a court order. And often if you have power of attorney, you don't need guardianship, but it's helpful for everybody if you get those terms straight. So if you're talking to somebody and you just have power of attorney and say you have guardianship for your mom or your spouse or whatever, that's going to imply a number of other things, and so you don't want to mislead people on that. I just thought this was funny. I know if you watched some of the previous webinars, I had this up before, but I was bitten by a radioactive lawyer. I ended up with power of attorney. Well, that's not exactly how that works, but You know, power of attorney is it has actually nothing to do with attorneys, of course, other than the attorney drafts it. But the power of attorney is you're appointing not your attorney, but your loved one, the one person that you trust, whether it's your spouse or your child or your sister or brother or whatever, by appointing them as your agent or somebody that can act for you, it's now that they have your power of attorney, even if they never went to law school. And they don't have to have been bitten by a radioactive lawyer. One of the things, we've been kind of belaboring this point a little bit, but it's really important to have a thorough, all encompassing plan. And so people will come in, we get this call all the time. We've trained the staff because this is such a frequent call. Somebody will call up and they say, I need to get power of attorney for my dad. I need to get power of attorney for my spouse. That tells me something is wrong, and it's not just, hey, I woke up one day and said I need to get, you know, my dad needs to appoint me power of attorney, or my spouse wants to, or I want to appoint my spouse power of attorney, or whatever it is. I didn't just wake up one day and decide I want to call it. There's a problem there. There's some, and so the idea here is it's not just about one legal document. Okay, it's about making sure that we're addressing, okay, well, that probably means something happened. You know, if we get a son calling up saying, I need to get a power of attorney for my dad, it means dad is in the hospital, maybe has dementia, maybe is, you know, fallen, maybe, you know, was told by their doctor they should get power of attorney or something like that. Meaning there's a lot bigger issues, such as, oh, well, should we make sure the assets are aligned properly? Do we want to look at whether or not they're getting the right care? What about medical decisions? What about, could we qualify for any benefits to help them pay for care? Could we get the VA to help pay for somebody to come into their house and help them get care there? Could we get PACE or waiver? There's all these bigger picture things. So people will often call just saying they want power of attorney. What they really need is a more thorough, comprehensive review. And that is also the answer from the standpoint of how do you get the bank to accept your power of attorney? Well, two ways. One way is take the power of attorney to them when you're healthy, and make sure they put it on their computer, make sure they do all the reviews before you need to use it. And the second, and I think this is the better way, is for most of your assets, when we're talking about the financial part of it, is going to be that if we have it in the trust, if you remember, only works for those assets that we actually put in the trust, which is okay because you're in charge of the trust. So it doesn't mean that we're changing anything about your ownership of the trust. You still own it, you still own the asset, you still own the bank account, checking account, savings account, things like that. But the thing is, now the bank has accepted the trust. They've already accepted it when we formed the trust, okay? When we got to do our homework and make sure we align all the assets with the trust. So we give a copy of the necessary parts of the trust to the bank and the financial advisor and the financial company and the life insurance. We make sure all of the assets are aligned properly with the trust, so that when the time comes that the daughter needs to step up and help mom with her finances, or help dad with his finances, then they've already accepted the trust. Now all we have to do is have you declared the trustee. So it's kind of like president and vice president. Okay, dad is president until dad's not capable anymore. Now the vice president can step up into those shoes, and it's, you know, trustee and successor trustee. Successor trustee can step up and help out dad. Well, they've already accepted the terms of the trust, including the fact that the successor trustee can step up and help dad. So it usually works out a lot more smoothly that way. So just something to think about. With the healthcare one, just to reiterate, to kind of go back to the beginning, the healthcare one is going to be that person always gets to make their own decisions, right? And so if they're not accepting your healthcare power of attorney, it could be one of two things. Number one is that the person can still make their own decisions. And even if they had told you 100 times that they don't want life support, and now today they're saying life support, but if the doctor doesn't feel the person is, you know, if the doctor feels that they're still capable of making their own decisions, they're supposed to make their own decisions, even if it's opposite of decision what they made 100 times before, okay? The second thing is it could be it's an emergency. And so in an emergency, the medical staff's going to do what they do, right? So if you call the police, you call the paramedic, they're going to come and they're going to resuscitate. That's what they do. That's their job. They're not going to stop and call their lawyer and say, you know, I would give mouth to mouth. I would do CPR. I would get out those paddles and restart your heart, but I got to call my lawyer first, and it doesn't happen that way. So you might have that power of attorney. Now often if they're in a care facility or in the hospital, you might have a do not resuscitate order, but it's with the organization, it's with the hospital, it's with the facility. So the facility knows, okay, nope, we've got this on file. We're not going to call the paramedic. Okay, we're not going to do that. And so that's the idea behind it, is that in an emergency, you're often going to get treated. If you call the paramedic, they're going to come and do their job. Okay. Any questions? I'm going to have Savannah kind of click in here and see if we have any questions for today.
Yep, thanks, Bob. We actually do have a question. So on death, when a trust becomes irrevocable, must a new bank account be opened instead of the original one that is in the trust? At least one bank required that instead of just changing the existing account number, social security number to the trust EIN.
Yeah, that's a really interesting question, and we've done it both ways. I think technically you probably should consolidate everything in a new account. And the reason why is because once a revocable trust becomes irrevocable, you got to get a tax ID number for it. So typically with the trust, we're not going to have a tax ID. A revocable standard trust, we're not going to have a tax ID number, even if someone else was the trustee during lifetime. So dad and mom do the trust. We don't have a tax ID number. Dad passes away. Mom becomes incapacitated. Daughter steps up and becomes trustee, and she's operating as trustee for the last 10 years. We still don't need to get a tax ID number. The only time we get a tax ID number is after now mom dies. Okay, well, not because before mom died, everything was under her social security number. Well, that you're not supposed to have assets under that social security number anymore. And so it is actually appropriate to get a tax ID number, consolidate, open up a new account with that tax ID number, consolidate everything into that account. Obviously that's a little simplistic because depending on the type of account, you might not consolidate everything. We might be moving it from that account to other accounts, not necessarily consolidation. But so the technical answer is yes, they probably now. Depends on the situation. If we're gonna, sometimes if we're gonna be settling the estate really quickly, we're in accounts that are, if we're in accounts that are not interest bearing. So if it's an interest bearing account and it accumulates enough interest, we got to file a fiduciary tax return to close the estate. Okay, and so that's why you need a separate tax ID. So, but if we have everything in non-interest bearing accounts, it's not very much money. We're not going to end up accumulating anything that's going to be reported to the IRS. Has it been done without that? Yeah. Technically, the correct answer is you should get a tax ID number and open up a new account. So I know that's a little bit inconvenient, but that's what we're here for. And we're actually really bulking up our state administration process. What's occurred to me over the years, and I'll tell you, it's always been something that seemed that important to me, the estate administration process, what happens after death. But I realized lately, and especially under the Secure Act and some of the new laws, and just some of the troubles that I hear back stories from clients where they had some difficulty, that it really is some value now to make sure that we're doing everything right after death, right? And so we're really bulking up our estate administration department because we are now recommending folks get our advice to go through this process and do everything right and dot every I and cross every T. Particularly now because of the Secure Act, there's some really significant tax savings that we can have if we got proper advice. And so we've been working hard on making sure that we're going to be able to provide that advice long into the future. We've got a great department that we're developing for after death administration of the estate. Any other questions?
No, Bob, that is the only question that we have today.
All right. Well, I know this is a very specific topic, but it's just a reminder Feel free, if you are not a client of ours, we'd love to have an opportunity to talk to you. Savannah's going to talk to you about how you can get a free interview with us. If you are a client of ours, then well, you can still have that free 15-minute interview, and that's basically for us and you to figure out, okay, what's the next step if you have changes or you have questions or whatever. Do you need a consultation with an attorney, or is it just something we can handle in that 15 minutes? Is it something that we can, you know, how do we address whatever concern you have? So Savannah's going to talk to you about that and give you some instructions as how to get a hold of us for any of your needs. So thanks again for listening.
All right, thanks, Bob. Thanks again to all of you who joined us today for this webinar. As Bob mentioned, we do have an easy way for you to get in touch with our team and connect with us to have you interview us, make sure that we're the right firm for you. And then also, we need to make sure that we schedule the appointment with the correct attorney. We have 3 attorneys in our office, and each one kind of has their own focus. So it's great to make sure that we put you with the person who can help you the best. So you should have an email. It should already be in your inbox. If not, it should be there any minute. And you'll have instructions for how to schedule that 15-minute call. Now remember, this is a free call. There's no risk at all to scheduling this. You'll open up a link. It'll take you to a calendar. You'll actually choose the day and time that works best for you. And Katie from our team will give you a call. During that call, she'll ask you a few questions, get some information about your concerns and what you're looking for, and then you'll also have the opportunity to ask questions about our firm, the process, anything that you'd like to know. And again, that 15-minute call is absolutely free and there's no risk. So do check your email, go ahead and schedule that call, and we hope to hear from you soon. And of course, we'll see you next week at 2 p.m. Have a great day.